Good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. So I have a topic to talk to you about tonight. I've been getting a lot of questions about the marriage-based process. And one question I got, and I did post the question on my latest video, was how long is this process taking? Because I've been waiting 4 months already. Now keep in mind that the average time for the marriage-based green card process is about 18 months to 2 years right now. Now, there are certain situations and where the cases are shorter, and I would say that those are the lucky few. I also, in certain cases, you could request an expedite if you're experiencing certain urgent humanitarian grounds, or if there is going to be a huge economic loss to a person or a company, or there is a USCIS error. So in those cases, you could request an expedite, so submit an expedite request to see if they will move your case along faster. However, outside of that, you are looking at an 18-month to 2-year process. Now, I am here to answer your U.S. immigration related questions, so don't hesitate to put your questions in the comments. I'm going to be talking about the marriage-based process overall. I'm going to talk about the marriage-based adjustment of status process. That's a process of applying in the United States. And then I'm going to talk about the consular process. What does that look like? So if your spouse, if you're a U.S. citizen or you're a resident and your spouse is outside of the United States, then in that case, you would be looking at consular processing. But if your spouse is in the United States and you're a U.S. citizen, or you're a resident and your spouse qualifies for adjustment of status, then of course you call it just that, adjustment of status. The first thing is I want to distinguish. So there is the marriage-based process where you're married to a U.S. citizen, and then there's a marriage-based process where you're married to a resident. Now, there are some differences between the two. So one difference is that being married to a U.S. citizen gives you a little more leeway in regards to adjustment of status. So for instance, if you're here in the United States, you've ended up overstaying, or you ended up, you're out of status now, your status expired, you may very well still be able to qualify for adjustment of status, meaning you can stay here and continue to apply for your green card. Also, spouses of U.S. citizens don't have to wait for what's called an immigrant visa number to become available. That's what creates a lot of the backlog, is that waiting for the immigrant visa number to become available. But a spouse of a resident does have to wait for an immigrant visa number to become available. The good news is right now, spouses of residents, there is no wait list for that immigrant visa number. And so once you get your petition gets approved, your process goes straight through to the embassy, to the National Visa Center, and then to the embassy for an interview, to be scheduled for an interview. So one thing I like to say is, if you are the spouse of a resident, schedule a consultation with me. Let's get started on your case. But first, let's fully evaluate your circumstances and determine how you're going to apply and what that process is going to look like and whether you qualify for that process. So in order to do that, you can always go to the link in my bio and then go to the website. There is a scheduling coordinator who is available up until 11 p.m. tonight to take your call and get on my schedule. Now, those are the differences, right? When a U.S. citizen is applying for you versus a spouse of a resident versus a resident applying for you, right? But right now they're on the same timeline, just because if a resident is applying for you, there's no wait list for the immigrant visa number to become available. So let's first talk about the adjustment of status application. So the number one concern with many spouses is, I don't have my status. I'm the spouse of a U.S. citizen. I don't have status. Can I still stay in the United States and apply? Now, it depends. If you came into the country with a permissible visa, even if you overstayed that visa, you could, it's very likely you qualify for adjustment of status, as long as you don't have any other disqualifying issues going on in your background. Now, if you came into the country without permission, you weren't inspected, in that case, unfortunately, you would qualify for permanent residence, but you wouldn't qualify to stay in the United States and apply for permanent residence. There is a different process. It's called a waiver process, where you have to use the waiver to fix your status. And that's a whole new topic for another day. I did touch on that topic in the past. I have touched on it, and I will certainly touch on it in the future. So if you feel like you fall within this category, what my first advice to you is schedule a consultation, and then let's fully evaluate your circumstances and get started on that waiver for you. Now, in the case also that you came into the country with a certain type of visa, certain types of visas do not allow you to adjust status. Now, it's the J1 if you have a 2-year foreign residency requirement and you didn't return to your country for 2 years, because when you have the J1, if you're subject to the foreign residency requirement, that means that once you're finished with the J1, you have to go back to your country or go outside of the United States for 2 years before you can return and go on to get another status. And then also the crewman's visa. If you have that, that's usually for people who work on ships and airlines, that they use this to enter the United States for work, to work on planes and ships. However, if you end up overstaying on that, it does not allow for adjustment of status. And so it becomes a very messy situation, because then you become inadmissible, and then you end up, if you have to go do consular processing, that turns into a complication. So what can I do if my second COVID shot is after my interview? So usually if it's after the interview, what the officer will do is give you an opportunity to send in your vaccination record showing that you completed the vaccination afterward. Now, ADLAM 22, I'm not your attorney. I don't know what your case is. If you want personal legal advice, you should schedule a consultation. However, this is the general information right now. If you completed your medical before October 1st, then it's not required, because the COVID vaccination is required in the medical ADLAM. So if you completed your medical, it was signed, it was properly submitted to the USCIS before October 1st, which is tomorrow, then you should be okay. That should not prevent you from being approved at your interview. However, if you say you did your interview already and they said, well, your medical has expired. Say you did the interview today and they said your medical has expired, or your medical was invalid, we need you to do another one. In this case, since of course you would be doing the medical tomorrow or sometime after October 1st, at that point you would have to get the COVID shot. But if at the interview it is required and you don't have the shot, they will give you an opportunity to send it in at a later date. And then once you send it in, they can, as long as they don't need anything else, they would close your case and hopefully approve your case or make a decision on your case. Keep those questions coming, because remember, I'm here to answer your U.S. immigration related questions. So put those questions in the comments right now so that I may answer your questions. Now, I am talking about the marriage-based process, both through adjustment of status, that's when you're in the United States applying for the green card, and then the process if you're a spouse, if you're a resident or a citizen and your spouse is outside of the United States, that's referred to as consular processing. I talked about the differences between being a citizen and then being a citizen applying for your spouse and being a resident applying for the spouse. And also, when you're here, when you're a U.S. citizen and you're applying for your immigrant spouse, when will they qualify for adjustment of status? And so they will qualify if they are currently maintain legal status, or if they also, if they overstayed but they came in, they were inspected at the border, and they came in with a permissible, qualifying type of inspection. Remember that there may be two types of visas that could render you inadmissible. I'm not inadmissible, but ineligible for adjustment of status, and that will be if you have the 2-year foreign residency requirement and you're within those 2 years, or you have the crewman's visa and you overstayed on that one. That can spell trouble for you. Now, if you snuck across the border without permission, that's going to be a different process. That's going to be the waiver process. That will likely mean you don't qualify to stay in the United States, unless if you did sneak across the border or you came in without inspection and your spouse is in the military, then you could possibly be paroled into the country. And that's submitting an application to the local USCIS office. And then if they approve the parole, then you would basically have permission to complete adjustment of status here. So that's one way to fix a situation if you have a military spouse. So you have to take the vaccine for you to get your papers from immigration. So yes, starting tomorrow, that it's going to be required for them in the medical. So remember, when you're applying for permanent residence, you have to do the medical examination. And a part of it is that you have to show your vaccination records, or you have to show a reason why you don't have your vaccination records or why you're exempt from receiving a vaccination. And now, a part of the vaccination requirements is that you have to have the COVID vaccine to successfully complete the medical. So if you and the person have never met in person, can you apply for the fiancé visa? So generally, you have to meet in person. La Belle, you're welcome. You have to meet in person, right? Within the last 2 years, the most 2 recent years before applying. However, there are circumstances where it may be very difficult, if maybe not even impossible, to meet in person, but you still are engaged. And so there are exceptional circumstances that is preventing you from meeting in person, such as, for example, if there's conflict in the country, or if there's instability, or if you will face persecution in that country, then that's an example of an extraordinary, exceptional circumstances that's preventing you from meeting in person. And also, if it's in your culture, it's a part of your culture or a part of your religion to not meet your fiancé in person, then that could also be a reason. You would have to submit the evidence to show that you meet the exceptions to the general rule that you must meet in person. How long does it take to get citizenship after applying? So Phantom Phoenix, my cases have been ranged from 2 months to 6 months. So that's why it's a great time to apply for citizenship. Now keep in mind that the results that I'm getting from my clients, so any past results that I've gotten from my clients may not be the same for future cases. However, the cases, the citizenship applications for me is 2 to 6 months. But this is not the same across the board. So other individuals I've heard say, for example, I see people coming on here and say, I'm still waiting for my citizenship application to be processed. And so the time varies. One thing that you can look at, Shawana, you're welcome. One thing you can do is if you have your N400, that's the application you use to apply for citizenship. If it's pending, you can go to the service center that is processing your application, and you can look at the range of time that they are taking to process your application. Great questions. Keep those questions coming. That's exactly why I'm here. I'm here to answer questions just like this. Now, I'm also talking about the marriage-based adjustment of status. That's when you're in the U.S. and consular processing, when your immigrant spouse is outside of the United States. So they're under the spouses of U.S. citizens can possibly qualify if they've been inspected at the border or been inspected coming in, even if they've overstayed. Now, it's different for a resident. If the resident is applying for their spouse, they must be in status or they have to complete the process outside of the United States. Is there any option for someone that came to the U.S. on a J1 visa who overstayed? So you have to qualify in some way. You have to qualify through an employer, through family, through other forms of relief such as a T visa, a U visa, or asylum. You can't just come in on a non-immigrant visa and then overstay and get status. You have to have some kind of qualifying circumstances or qualifying relative or employer that can help you to move from J1 to another status. And keep in mind, there's an additional consideration with the J1. The J1 is for, some of them are subject to the 2-year foreign residency requirement, where when they're finished with their program, they must leave the United States for 2 years before coming back to get a status. What type of questions do the couples get at the interview? So the couples can get all sorts of questions. So make sure you sit down and speak with your spouse. Make sure you're on the same page. So common questions, remember, I can't predict. It's not at the same set of questions. The officer is going to review your application, and they're going to ask questions based on what they see in the facts. So they may touch on some of the most common questions that I've observed is, how did you meet? When did you meet? When did you get married? Have you met your in-laws? What are the in-laws' names? What is the mother-in-law name? What is the father-in-law name? Your routines. Who gets up first? What's the color of your curtains in the room? Hi there, Suyenya. It's nice to see you. What's the color in your room? How many people were at your wedding? So what I would say is I'd break it down to this. Questions about the wedding, personal questions about each of you. Date of birth. What's your date of birth? What's your favorite thing to do? What are your hobbies? What do you do for a living? So personal questions, routine, anything based on routine, family members, and they could even touch on deeply personal questions like family planning in the future. So make sure that you are in tune with your spouse and that you talk about these things before going into the interview. So if I purchase a house in the USA, would immigration stop me from coming to the USA often? So user 7978, if they have a reason to stop you from coming to the US, they can do that. And so you can't buy a house and use the house as a means to live here. You have to abide by the terms of your visa and the time limit that they give you. And so while you're free to buy a house, you have to also take into consideration that you must comply with the terms of your visa or your visit if you're coming here on a waiver program. And that, yes, there is always that possibility that they could stop you, that they could tell you that limit the time that you are here in the United States. What happened when you apply for a 10-year green card and you get into a divorce? So if you got a 10-year green card and you get divorced, there is nothing that can happen. Now, I'm talking about cases where it was a bona fide marriage, it was a real marriage, it just didn't work out, and you already have your 10-year. Now, if you're talking about going from a 2-year green card to a 10-year green card, you're in the middle of the process and you're getting a divorce, then at that point you have to apply for a waiver based on the divorce. So this is an area I work with my clients on. So you give me a call, schedule a consultation. I can help you to file that divorce waiver. Now, with the divorce waiver, when you're going from a 2-year to a 10-year and in the middle of your application you get divorced, it's going to involve showing you have a bona fide marriage and then showing that you are divorced. Annie B. Harry, thanks for the follow. Can biometrics taken for a global entry be used for biometrics for your green card? So if it is immigration related, so if it's done at a USCIS office, then it is on their record and they could possibly reuse it. But in the case that they feel like they can't reuse it, they will send you a biometrics notice. Hi there, Payne, it's nice to see you. Thanks for joining in. I appreciate it. So keep your questions coming because that's exactly why I'm here. I'm here to answer your U.S. immigration related questions. I am talking, so I already applied, I had fingerprints done, but just started a divorce. That is a problem. So yeah, if you, Suyanya, call, schedule a consultation. Hi there, Dark Horse 45. So nice to see you. Because you want to make sure you approach this correctly. If you don't, you could face problems in your application. I don't give personal legal advice here, but I'm telling you that at this point, you need to get legal advice and guidance through the process. Because if you are in the middle of a divorce, you can't just apply with your spouse's signature. You have to go through a waiver process to be able to apply on your own. There is a way to still apply on your own, but you need to be careful to make sure that you do it correctly. LaBelle, I'm glad. That is exactly why I'm here every day, is to be helpful and give you information that is useful to you. So keep your questions coming. So what I'm talking about now is the marriage-based adjustment of status. So if you qualify for adjustment of status and you've determined that, that's where it's very important for you to schedule a consultation to determine whether you qualify. Now, once we've determined that you qualify in a consultation, the next step would be to apply. Now, when you're here and you're doing adjustment of status, there are many convenient benefits to adjustment of status on a marriage-based adjustment of status. You get a work permit. Work permits are taking about 6 to 8 months. Now you get a travel document if you want one. And then you can stay in the United States. So at no point in the adjustment of status process will you need to leave. So that means you get to be with your spouse. You get to be with your family while you obtain the permanent residence. How long after marriage can you put in the paperwork? So baby gal Davi, that's where it's important to schedule a consultation to make sure that you're on the right path and you're not making mistakes in your case. Timing can affect the tone of your application, because if you do get married, so for example, say you come in on a Friday, you get married on a Saturday, and you file your paperwork on a Monday, that could indicate to the officer that if you came into the country with a visa and then you overstayed, that at the time you came in, you were planning to stay because you got married on Saturday, you came in Friday, got married on Saturday, and then filed your papers on Monday. And so in a case like that, it could very well spell trouble for you. And so that's why it's important to ask those specific questions in a consultation so I can properly give you legal advice. The information that I'm giving you right now is general information. It's not personal legal advice. So my answer to that, under immigration law, there's nothing that says you can't file the paperwork right after getting married. As a matter of fact, I have done that for my clients, but their circumstances, in their situation, it was okay to do that. However, in certain circumstances, it could actually put your permanent residence in jeopardy. So Suyenya, if you are confused, you need a consultation. So if you are confused at this point, you need to get a consultation because that means you need a personal explanation and personal advice to help to guide you forward. So keep your questions coming because I'm here to answer your U.S. immigration related questions. So now, once you apply for adjustment of status, so when someone divorced, when can they get married again? So if this is, with immigration, divorcing someone right away and then remarrying right away, and it shouldn't be a problem unless you are applying. Now you've divorced, you got your green card through someone else, you divorced them, and now you're marrying someone else. It would depend on the facts, it would depend on your circumstances. But in the immigration context, it just depends. It depends on the timeline. How did you get your papers? And so once again, it depends on your particular circumstances. How long does a refugee green card take? So if you are applying for adjustment of status based on asylum, you should go to the service center that's processing your case and look at the timeline that they're taking. The timeline varies based on who is processing your case, the service center that's processing your case. So once you apply for adjustment of status, you can apply for a work permit, a travel document, while you are applying. Work permits right now are taking 6 to 8 months from the time that you have applied. And then once you've applied, right now it's taking 3 to 4 months. That's because of the backlog. You get a fingerprinting appointment. If you somehow already have your fingerprints in the system, they could reuse those fingerprints. But normally you would expect an adjustment of status, a biometrics appointment. Once you do the biometrics, usually after the biometrics, you get the work permit sometime after that. Then you could expect an interview. Now, in between all of this, you may just get a request for evidence if your application is incomplete or they have additional questions. And so that could always be a possibility. Do you think you can help someone who overstayed on a J1? So honey 24, what you need to do is schedule a consultation. I help clients who have overstayed in all different circumstances, including the J1. But it depends. Whether you qualify for an immigration benefit or form of relief is going to depend on your particular circumstances. When will they be opening up visitors visas application process? So each embassy is different, Showanana. It's different because you have different COVID situations, you have different conditions in different countries. So you should visit the embassy in your country to see if on their website, on the official website, if they have provided notifications about what they're doing with visitors visas right now. After USCIS reschedule your green card interview, how long does it take to get another date? So you could be looking at months, unfortunately. You could be looking at 3 months, and I've even seen as long as 12 months. So it's really unpredictable right now, and it depends on how inundated the USCIS office is, how backlogged they are. And so it's really just depends. There's no way to give you a definitive answer on that one, just a time range. So keep your questions coming. So I basically finished with the topic of adjustment of status. I even earlier, due to a great question, I went over the interview questions when you get to the interview. Now, VAWA case approved after remarried to another spouse. So that does not sound right, Sanusi. If you remarried, you become ineligible for VAWA. And so if you got approved after you remarried someone else, that means that they probably didn't have their records up to date and it was granted in error. And that if a green card is granted in error, it could harm your ability to get citizenship in the future. As a matter of fact, you may even very well get your green card revoked. And that's if you're applying for a VAWA, because VAWA, if you have the VAWA status and then you go on to get the green card and then you're going for citizenship, that is what could happen there. And so I don't know the full facts, Sanusi, and so if that is something that you're worried about, schedule a consultation. How long after you receive your adjustment of status do you an appointment for? Okay, so how long do you get the interview for the adjustment of status interview? So you could be looking at about 18 months. It could be 9 months, so 9 months to a year to even 18 months. What you could do is if you look at the service center, if you go to uscis.com and you go to case processing times, it's on the homepage, just scroll down. You put in the service center that has your case, you put in the form, so the I-485, you'll be able to get an idea of the range of time you could be looking at before you get an interview. When someone overstayed their visitor's visa, they're working, paying taxes, can they get a green card? So Annie B. Harry, unfortunately, it's not automatically granted as a result of paying taxes. You have to be able to qualify in some way. So you have to qualify right now. You have to qualify through an employer, qualify through a family member, qualify through humanitarian means, meaning like asylum, or if you've been the victim of a crime or been the victim of trafficking. Now, right now, they are looking at different plans or provisions to try to assist immigrants who are undocumented, immigrants who are paying taxes, who ended up overstaying, but they're here and they're contributing. And so we have the reconciliation bill. I don't know if you've heard about it, but an immigration provision was included in it. It was not approved after review by the powers that be. In this case, it was the Senate parliamentarian who reviewed the immigration provision and said that it cannot work. They will not allow it to go forward in the reconciliation bill. They came with a plan B to be able to allow people who came in before a certain date. I've heard 2010 or even January 1st, 2021, to be able to register if they meet certain requirements and then gain permanent residence. However, that was also shut down by the Senate parliamentarian. And now I'm hearing about a Plan C proposal. This one would be, nothing has been confirmed, nothing has been officially published, but there have been suggestions by certain senators that the third proposal could be to just provide work permits to individuals, not necessarily status, some formal status. However, nothing has been published and we'll have to keep an eye on it. That could possibly be a way that undocumented individuals who don't have any other path to legal status could get it. But for right now, as the law stands, you have to qualify in some way to get that, to be able to get the green card. If you've been married to your spouse for 16 months, will I get a conditional green card? Yes. So if you've been married for under 24 months, under 2 years, you get the 2-year green card. Now, if at the interview, at the time that you go to the interview and you get approved, if at that time you've been married for more than 2 years, then you get the 10-year. If when you go to the interview for permanent resident card and your spouse doesn't show up, that's a problem. If it's marriage based and the spouse doesn't show up, that's going to be a major problem. And it's going to, you either have to have a really good explanation, but they're just gonna, you would be lucky if they reschedule the interview, because they may suggest that they reschedule and you bring your spouse, but that is gonna be a big problem. I-601 is submitted with I-485 together or after the interview. So it could go both ways. It just depends. Sometimes you go to the interview and you find out that you are inadmissible, and at that point you have to submit your I-601. Even though we've been together since 2018, so yes, call me daddy, you have to be married so it doesn't count. The time that you've been together doesn't count before you are married. It only counts after you've been married. So this conversation doesn't have to end here. I didn't get to touch on consular processing. That's where the spouse is outside of the United States. But I'm going to be back tomorrow night, and I will bring that information tomorrow to talk about consular processing, being a resident, being a U.S. citizen, and applying for your spouse while they are outside of the United States. I have pre-scheduled live on Instagram. This conversation doesn't have to end here. If you have more questions, go ahead, hop on over to Instagram. You can go to the link in my bio. It'll take you, you see an Instagram button, you can go there. Or you can go straight to Instagram and just type in The Immigration Attorney and then join me. Follow me and then join me there, where you can continue to ask questions, and then we can continue to have this conversation. So if you need personal legal advice, which, remember, the information I'm giving you here is general information. It's not personal legal advice. So don't act on it until you get advice in a consultation. And I'm available for personal consultations. You can go to the link in my bio, then go to the website where you can call, you can do the online chat, or you can complete a contact form. So 3 very convenient ways to get in touch with me. A scheduling coordinator is available up until 11 p.m. tonight to take your call and schedule your consultation. So I see some more questions. I am going to go over to Instagram, so please join me over there, or join me tomorrow at 9 p.m. Eastern time. Have a good night, everyone.